Happy first Friday of the year.
Yes. Happy New Year to you too.
Happy New Year. It's January 4th, 2019, and together, new year, new us. Any resolutions?
Oh, yeah, none that I can share because I won't keep them. So I'll look really bad.
Thank God it was that rather than none that I can share because they're all embarrassing.
Yeah, no.
So today we're talking with Rhonda Cordova. Hello from Kaplan Morrell to all our friends, colleagues, coworkers of Colorado, and clients and prospective clients. And today we are going to be talking. We're going to be doing a celebration, and I was going to get some champagne.
The hot sauce is for.
I was going to get some champagne, but the bottle's empty. Because we're
Somebody celebrated without me.
Apparently, and I was gonna get some cigars, but I didn't. So I'm gonna sip on some hot sauce from Fuzzy's Tacos. It's called butt burning hot sauce. While Rhonda talks about one of the victories that we had, we're not going to use our clients' names, but one of the victories we had at the appeals level, because that means that Rhonda went to court and she won against a particular employer. We won't even name the employer, but let's just say that the employer, we'll just call them Sing Poopers, okay, right?
Okay.
Yeah, I don't know what they do, but anyway, she went to court for a client of ours, and we won, and the employer appealed, and we just got the appeal back, and it's got some great lessons for injured workers, because and why you shouldn't wait to talk with an attorney, because I think this client was kind of had a false sense of security about, I don't need a lawyer because everyone's being so helpful and nice, right?
Yeah.
So why don't you give us a praise sip, and I will down my celebratory Fuzzy's butt burning sauce
Okay.
instead of a cigar,
Very good. Okay, so one of the first things that this case kind of shows us is when my client was injured, it became a compensable claim right away, but the problem was she didn't exercise her right that she could have to change doctors. So unfortunately, she got into one of the clinics that's very well known for, you get the injured worker in there and you get them out and get them done treating as fast as possible.
And I'm trying to remember the name of the clinic. I'm trying to concentrate on who they could be, but
Yeah.
bottom line is, if you think of concentration while you're at this clinic, you're in the wrong place.
Exactly. So she's injured in 2016 and only gets literally at best what you might consider 2 months of medical treatment at best. And this was a back injury. And so potentially she needed a lot more care than that, but she didn't have counsel, and she treated, like I said, at this clinic that didn't properly take care of her. So then she gets released from care. She's an older woman and gets no permanent work restrictions, gets assessed for no permanent damage to her back, and is put right back in her regular duty job.
Which means that she was cured, right?
Right. She was
cured.
Better. Yeah.
Hallelujah.
She was all better. All better with, I think, a minimum of, I believe she went to physical therapy twice.
Yeah.
And may have been
spoiler alert, she wasn't cured.
Right.
But.
Yes. So, and then what the carrier did, which is unusual, because a lot of times they won't file anything at all, but they did file paperwork to conclude her case. They filed what was called a final admission of liability. That would have given her, again, had she had counsel involved in her case, an opportunity to challenge what that treating physician had said. She could have challenged that she needed more care, that she never had any diagnostic done, like an MRI, but she didn't have counsel. So her claim gets closed down, and she doesn't seek any counsel advice on that. Then what happens is within, I would say, 2 weeks at best of, well, in fact, she actually suffers what she thinks is another injury, or maybe her first injury just became worse. Whatever that happens right before this final admission of liability gets filed. So now would have been another opportunity for her to be talking to somebody about, what do I do? Now I'm having continued new pain, different pain, same pain, whatever from doing my job. I have a problem here. She didn't have counsel at that point, and instead tries to get her employer to pay attention to the fact that she's having problems again. There is a language barrier. The employer knows she had a prior claim. They try to treat it as the same thing, only not give her care. Somehow they turned it into, well, if it's the same thing it was before, that case is done.
You're cured.
You're cured. You don't need anything from us. There was dependence on her family to try to get her care. That fell on deaf ears with the employer because they weren't talking to her as the injured worker. Just huge problems. She ends up being surgical. And unfortunately, because there was a new claim wasn't filed or the old claim wasn't reopened, again, the help of counsel, she ends up having to just have these basically two kind of emergent surgeries, if you will, that weren't getting paid by anybody. And then she starts losing time from work, of course. And so there she is now finally coming to counsel to say, I don't know if this is my same injury, if this is a new injury. So that's where she ended up. And I think, again, going clear back in time, a lot of that could have been avoided and didn't require a hearing and then an appeal.
Well, one of the things that struck me about the case and the decision is that she was essentially stuck in limbo.
Yes.
And because the employer, I mean, it's weird enough. It's understandable when you have two different employers and there's a question, okay, is this injury part of your employment with employer A versus employer B? But here you're still with the same employer, and the employer is kind of playing this game. Well, I don't know if it's the old injury or I don't know if it's the new injury, and so until we can kind of figure that out, we're not going to do anything. And the status quo is basically, you're hurt, you need care, and the insurance company is basically scratching its head saying, well, we don't know where to file this. And you'd think, well, I could tell you where to file it, but more importantly, well, who cares? Get me the care while you're trying to figure it out. And they weren't. And so that's why you kind of need to start talking to a lawyer sooner rather than later, because the insurance company is perfectly fine with what's called the status quo, which is they ain't paying anything while you're trying to hopefully convince them on your own to do that, and that won't happen. So you filed two things. You filed a petition to reopen the old claim.
Correct.
And you filed a work comp claim for a new injury. Correct. So one was the June 2016 old claim. I'm going to try to reopen that. And if the care isn't due to a worsening of the old injury, I'm filing a new claim for February 2017.
Correct.
And you would think, great, okay, now the carrier will take it seriously, except they decided to fight everything, correct?
Correct.
And so what was their argument?
They tried unsuccessfully to say it wasn't either. It wasn't the original injury getting worse, and it wasn't a new injury. She must have done this somewhere else.
But were they able to point to anything, any medical record, any statement that she said, oh, by the way, I went boating or anything like that, and I got thrown off the boat, and that, or there wasn't a motor vehicle accident, there was nothing. It was just, we think it happened, but we don't know what it was.
Because she was 100%. They relied on that first doctor's release of you had no restrictions, you were 100%, and you've been doing your same job, can't possibly be the first injury, and you did not report correctly a new injury. That there was, because of that confusion over, do I have something new or something old? They wanted to, then the second argument was hang our hat on, and there's no new injury. So maybe there was an old injury, it didn't get worse, nothing happened to you there, and now you haven't properly reported a brand new one, so it can't be a new injury because of You didn't say, I hurt myself tonight at this time, at this place.
But that's one of the reasons why, if you're injured on the job and you start to feel like you are having to explain things repeatedly, that's a big sign that you need an attorney. Because in addition, I mean, yes, there was a language barrier for this lady. But in addition to that, every time you start giving recorded statements, you start writing things down, the more you do that, the more that there's going to be some inevitable differences between what you say today versus what you said 3 months ago, unless you've got everything there in front of you. And as attorneys, we can help our clients because we don't let you answer those questions until you've reviewed what you wrote down or said back then, so that you're not shooting from the hip on these statements. And some of the ways that she was explaining things, they were using against her because she didn't say or use magic words like, this is a new injury, or this is a continuation of the old injury, because frankly, she didn't know.
Right, and why should she be expected to know? We could help with that part of the fact that, our client doesn't know.
So what was curious to me in the appeal, because what the judge eventually did is the judge said, this is a worsening of the old condition.
That's correct.
I'm reopening the June 2016 claim. And you would think normally 80% of the time that would finish it. They'd say, okay, we're reopening it. But instead, this employer who rhymes with Sing Poopers decided, and I know what Sing Poopers does, by the way. They go and they clean yards from dog waste. That's what they do. And they sing while you do it. So in addition to your lawn getting cleaned, you're also getting serenaded. It's very nice.
Yes.
So they file an appeal not on the case that they won, which is I'm dismissing a February 2017 claim. Right. They only file an appeal on the judge shouldn't have reopened the June 2016. And what's curious about their argument is they keep saying, we had a brief interruption. What was curious is they keep saying in their argument, all of the evidence suggests really that it was a new injury.
Yes.
Right?
That is kind of what they said.
And so I would have been tempted to go, but they're not admitting on the new injury.
That's correct.
Right?
That's correct.
I mean, it was kind of like,
yes.
Oh, we're offended that we have to take care of this based on a June 2016 injury, when really everybody says it really should have been a February 2017 injury, which we denied, and we're not wanting to pay for it under that anyway. I mean, what was going on there?
I think the one thing that really kind of stuck out for them and what they were hoping would win the day was our own expert did identify that something very surgical and acute took place
in February.
Right after that February.
Oh, right, but
supposed incident, right? So, again, what I think the judge was doing was saying, look, we don't know what her condition looked like when she got released. I mean, our expert's going to look at the medical records and say, well, this doctor said she was okay. But the judge knows enough to know, well, that's not long enough to address the issue. And so he took it upon himself to say, I don't know where she was at, but now I do see that she's definitely worse. So I'm going to hold up the part of the expert's opinion that said work definitely caused this problem initially, and I don't have to rely on that expert to tell me it was a February injury, but instead I'm going to find the progression.
Because was that expert opinion also that there was no work injury, that her current need for care wasn't related to anything? Was that also?
Oh no, very much he knew it was work. I mean, there was no ifs, ands, or buts about the fact that job that she was doing caused injury to her back.
So even though their own expert, Sing Pooper's own expert, was saying,
no, it wasn't their expert. Well, it was one of the treaters they didn't want to pay for.
Correct, but
the surgical expert.
But it was a treater that they had
Yes.
that they had selected. So even
Yes.
their own treating
Yes.
physician said this is a work-related condition. They were still fighting having to pay anything.
Yeah.
And that's one thing that you kind of also need to understand is that even if the quote-unquote company doctor is saying things that are supportive of you getting medical care for an injury, the insurance company can still say, no, we don't want to accept that opinion either, and still fight it.
Yes.
And so, big takeaways: talk with us. If you start
As early as possible.
Yeah, if you start getting the runaround, if you start getting delays in your care, you need to really focus on what they're actually paying for as opposed to what they're telling you, because they'll be like, oh, don't worry, we're still reviewing it. They can be very supportive, but what really matters isn't what they're saying, it's what they're actually doing. And if they're not paying, they are perfectly fine to keep it there.
Yeah, and unfortunately she didn't see me until after that second urgent surgery.
Yeah.
So when they figured out that the insurance carrier was not going to pay for surgery was when she was in my office, and that was obviously long after the first injury.
So good. Well, I'm glad it was a win.
Yeah.
And the sauce was...
Was it good?
Yeah, it didn't...
You didn't even share it. You know, when you're supposed to
Well,
be toasting,
I've got
you're
another
supposed to
one
share.
if you really want to... I mean, I think I would have preferred
I don't want to
the
share that one
champagne.
either.
I would have preferred the champagne. So, again, as always, if you or someone you know are injured on the job, feel free to give us a call at 970-356-9898. We would be happy to talk with you, help you, give you a free consultation. And with that, have a great and fabulous weekend. Rhonda, congratulations on the win.
Thank you.
And we will talk with you later. Bye.